Good morning, everybody. Today is Wednesday, July 1st, and my name is Sandy Andre, and you have joined us this morning for the Miller-Johnson Coronavirus COVID Response Team daily webinar. Today, we are going to be talking about your obligations as an employer when you have an employee requesting leave or another accommodation because they are in regular contact with a vulnerable person. But before we jump into our topic this morning, I just want to share a few of the COVID-19 related headlines from the last day or so. So here in Michigan, we had a couple of developments yesterday that were breaking news. Yesterday, Governor Whitmer had the opportunity to announce her plan for schools to return to in-person learning this fall by releasing her return to school roadmap. Additionally, she did announce that Michigan, as a state, the entire state will not be moving into phase 5 by the 4th of July weekend, which is something that she had hoped to do, and that was a date that she was targeting and has been talking about for a while, but officially yesterday she told us that not all regions will be moving to phase 5 by this coming holiday weekend. And unfortunately, as we look at the data from across the state, it even appears that two regions, the Grand Rapids region and the Lansing region, at least in terms of exposure risk, have moved a little backwards from, excuse me, from a medium risk to a medium high risk for the Grand Rapids area and moving backwards for the Lansing area as well. So what we know, all of those things in totality, is the virus is not going away, and so we move forward and will continue to be faced with employment issues as a result of the virus in our communities. And so we jump back into our topic as we look at our employees who are out and about a little bit more maybe than they were a couple of months ago, and making sure that we understand our obligations as the employer on when we need to consider accommodation requests for those employees. So our topics today, we will first spend a quick moment or so with a brief review of the federal and state protections and benefits that your employees may have access to related to the health status of another person. So generally, we have a pretty good handle on, if I'm the employee and I have my own medical issue and I've asked for leave or some other kind of accommodation, we understand what that analysis looks like a little bit better. But let's go ahead and review those federal and state protections regarding the health status of another person. We're also going to spend just a little bit of time talking about the Americans with Disability Act's association provision, not a provision that a lot of us work a lot with, just in regular dealings with our employees. So we'll spend a little bit of time on that and talk about why that is applicable to our current situation. Then we'll go ahead and just go through a couple of hypothetical scenarios that are similar to some of the client questions we've been getting over the last several weeks. So hopefully those will be helpful for you. Okay, now let's go ahead and move into talking about some of the federal protections and benefits that your employees have access to related to the health of another person. So we remember, of course, FMLA, that one of the reasons that an eligible employee may be able to take a leave for FMLA is related to the care of a covered family member for that family member's serious health condition. Okay, so FMLA is on the table. That serious health condition could be COVID-19 related or non-COVID-19 related. So the critical components when FMLA comes into play, when we're talking about the health status of someone other than your employee, is if your employee is required to care for that person, they need leave to do so, and that person's medical diagnosis hits that serious health condition threshold. Again, COVID-19 related or not. Then, of course, we know that since April 1st, several of us depending on the size of the employer that we are working for, we are representing, are subject to the paid leave provisions of the Families First Coronavirus Response Act. Specifically, the Emergency Paid Sick Leave Act is an avenue that your employees may utilize to take a leave of absence related to the health status of another person. So as we know by now, there are a number of reasons your employees may take emergency paid sick leave, and one of those, again, similar to the FMLA, it's leave, and it's related to care for a covered family member who is either subject to a federal, state, or local quarantine order, or care for a covered family member who has been advised by a healthcare provider to self-quarantine related to COVID-19. So as we look at this slide, we remember FMLA, of course, can be COVID-19 related or non-COVID-19 related. The Emergency Paid Sick Leave Act is specifically related to COVID-19 related reasons. So subject to a quarantine order from a government official, or has been advised by a healthcare provider to quarantine because of COVID-19, and your employee is the caregiver of that person. So those are some of the federal protections that are available. Now let's turn and talk about some of the state protections and benefits that are available to your employees related to the health status of someone they are around regularly. Of course, we remember the Michigan Paid Medical Leave Act, and this is not COVID-19 specific, of course. This has been in play in Michigan since March of 2019. And for those who may be listening from other states, there are many other states. In fact, we're now at the majority of other states have state-specific paid sick leave laws, and many of them cover reasons very similar to Michigan. So here in Michigan, of course, eligible employees can take, again, paid medical leave for reasons related to a covered family member's own illness, injury, health condition, preventative care, or related to leave for their family member as a result of the family member's victimization by domestic violence or sexual assault. So of course, these are COVID-19 or non-COVID-19 related reasons. Your employee needs leave to care for their child, as an example, for their child's health condition or healthcare provider appointment. Those types of requests are covered under Michigan Paid Medical Leave. And then as we look at the state of Michigan and additional leave provisions or additional benefit protections that have come on the scene in light of the COVID-19 pandemic, we turn to a couple of particular executive orders. The first is Executive Order number 36. And Executive Order 36 permits employees to take leave for a period of time after close contact with an individual who tests positive for COVID-19 or with an individual who displays one or more of the principal symptoms of COVID-19. So that individual may take leave for up to 14 days after their last close contact with that potentially infected individual, or they can take leave until the symptomatic individual receives a negative test. So if, a week ago I was in contact with someone who is now symptomatic and has been tested, I can take leave for up to 14 days from my last contact with them. So I already haven't had contact with them for a week, so I can take leave for another 14 days. The idea, of course, is is that we are isolating and out of the workplace for that 14-day incubation period. Or if that close contact calls me tomorrow and says, I just got tested and I'm negative, I can go back to work tomorrow. So as we look at, it's not me who is the symptomatic or potentially infected individual, it's someone I'm in close contact with. So Executive Order 36 is important. And a second executive order that is not an order that provides leave per se, next slide please, is Executive Order number 76. So this is the Unemployment Expansion Executive Order, and we just remember that any individual who leaves work because the individual is required to care for someone with a confirmed diagnosis of COVID-19 is going to be considered by the Unemployment Insurance Agency to have left work for a medical reason, and they will not be disqualified from unemployment benefit eligibility. So those are the state and federal protections and benefits that are available to your employees, depending on the size of the employer you are and eligibility standards for the employee. But those are the benefits and protections that are generally available to your employees that deal with their request for leave or some other benefit related to someone else's health status. Next slide, please. So now let's turn to the ADA. You might be saying, right, so the ADA was conspicuously absent from our previous discussion. You didn't see it on any of the previous slides. You might be saying, hey, Sandy, you missed the ADA. Reasonable accommodations regarding disabilities are required under the ADA, right? That's another opportunity for our employees to request remote work or leave of absence. How does that come into play? And so it's a good opportunity for us to have a little bit of a refresher. Remember that under the ADA, as an employer, our reasonable accommodation obligation is triggered only for the employee's own medical condition, and only to the extent that that medical condition meets the definition of a disability, and an accommodation would allow the employee to perform his or her essential job functions. So as we look at when does the ADA come into play, right, that box is checked when I'm contacting you as my employer and I'm saying I need leave because of my medical condition, or I need a reasonable accommodation because of my own medical condition. That's when a potential ADA accommodation comes on the scene. And as we know, based on pre-COVID times, there's a number of reasonable accommodations that can make sense, right? Extended breaks, all of those pieces. But as it specifically relates to COVID, what we're generally seeing, right, are employees' requests for remote work or a leave of absence. And both of those are examples of reasonable accommodations or accommodations that can be reasonable depending on the circumstances. So what's a little bit different, next slide please, let's talk about the ADA's association provision. So under the ADA also prohibits employment discrimination against a person, whether or not he or she has a disability, but because of that person's known relationship or association with a person with a known disability. So what does that mean? This means that an employer cannot make any adverse employment decisions based on unfounded concerns about the known disability of anyone that the employee has a relationship with. And we'll go through some examples. But what the ADA's association provision does not hold or does not require, it does not require the employer to engage in the reasonable accommodation process based on an employee's association with somebody who is disabled, okay? So that is the difference. It contains a non-discrimination requirement, but not an accommodation requirement, okay? Next slide, please. So as we look a little bit more at the association provision, it's somewhat helpful to think about, okay, what are we talking here? I certainly understand the words on the page, but what kind of conduct, let's talk through some examples, what kind of conduct is prohibited. So an employer cannot deny an employee any other benefit or privilege of employment that is available to others because of the disability of someone with whom the employee has a relationship or an association. So if I am offering all of my employees some kind of benefit or privilege, I can't deny it for the other employee simply because of their association with someone with a disability. And certainly, in addition to the non-discrimination requirement of the association provision, there is certainly also an anti-harassment requirement in that provision as well. So as the employer, you cannot subject someone to harassment, and you need to make sure that the employee is free from harassment from others that would be based on that person's association with a person with a disability. So making sure that that individual is not, subject to a hostile work environment, all of those pieces simply because of their relationship with somebody with a medical condition that hits the level of disability. So next slide, please. So let's talk about how the ADA association provision interplays and comes into this conversation we're having about COVID-19 and our current status in the pandemic. So as we look at requests for workplace accommodations, now that organizations are starting back up and people are coming back to work after, shifting to remote or even layoff for a period of time, we see various sectors of the economy open back up. And so organizations are calling their folks back to work, and some individuals are happy about that and happy to return to the workplace, and some folks have some genuine concerns about wanting to return. And so for you as an employer to try to figure out what concerns and what accommodations do I need to be going through a formal process, and which ones can I consider, but I'm not required to consider. Let's walk through those. So in terms of requests for workplace accommodation, remember that from an association standpoint, unless we're talking about the employee's own medical condition, you are not required to engage in that reasonable accommodation interactive process simply because your employee lives with a vulnerable person or is in regular contact with somebody who falls into kind of that vulnerable person category, okay? So although certainly an employee may ask for it and you can certainly consider it, you're not required to engage in that interactive process in the same way that you would be required to do so if it was the employee's own medical condition, okay? But where the association provision comes in is if you start to grant accommodation requests for employees for reasons other than the employee's own disability, we need to make sure that we're doing so on a non-discriminatory basis. So if you just have an employee who's generally fearful, for example, to come back to the workplace, and you're permitting that person to continue to work remotely for a time period, and then you have an individual who also requests remote work because they are in regular close contact with somebody who's in that vulnerable person category, we want to make sure that we're considering both of those requests. Doesn't mean that you have to grant both requests, but you're giving due consideration to both of them, and you're making the decision to grant or not grant on a non-discriminatory basis. So next slide, please. So what that means, okay, is we look at, okay, what's a non-discriminatory basis for granting such a request? So we know that that means it can't be based on any of the protected characteristics under Title VII, of course. So race, sex, religion, national origin. Here in Michigan, we have additional protections for height, weight, age, all of those pieces. So we know we can't say, we're gonna grant requests for everybody in this category, this protected category, and that's it. That's not where we want to draw those lines. And we know that we can't base those decisions on because of an individual's known relationship or association with a disability. So I'm going to say yes to people who have a general fear, but I'm going to say no to everybody, what doesn't qualify for leave ever or remote work ever is folks who live with a vulnerable person. Those aren't the lines we want to draw. But non-discriminatory reasons absolutely can be, you as an employer can make these decisions, right? You can say, we are only going to grant leave or accommodation requests for persons where we where we're legally required to, right? So as an employer, you absolutely can take the position that your company is only going to provide legally required accommodations or leaves, right? And depending on right, the volume or the backlog that you may have, or even the staffing concerns you might have, that absolutely is a legitimate business reason. One, from an economic standpoint, perhaps you just simply can't afford to have folks out, but two, from a staffing standpoint, you need folks in your facility, and granting everybody remote work or leaves, you've got to draw the line somewhere, and it's absolutely appropriate to say, we can only grant these accommodation requests when we're legally obligated to do so. Everything else, we have to just go back to whatever our policies allow and follow those. But essentially, you just want to make sure that those, the non-discriminatory basis for granting accommodations are based on legitimate business reasons. So if I were to look at some of your employment policies or the language in your employee handbook, I'm sure even under your, paid time off policies, you might have some language that talks about, vacation requests as an example, and that you typically grant those on a first come, first served basis, or based on seniority, or based on staffing, or, the economic conditions, or whatever those legitimate business reasons are. All of those reasons are perfectly acceptable. We just need to make sure that that is being applied consistently across your organization, and we have good documentation when we receive a request for an accommodation, including remote work or leave, kind of the analysis or the process we go through that helped us decide whether we were going to grant that or not grant that. Okay, before we jump into scenarios, we've gotten a couple of questions. And so I just want to take a look at what those are in the event that we can clear some of those off, and that can be helpful. So the first question, can the emergency sick leave be used for conditions under Executive Order 2020-36? So remember, 2020-36 talks about if I have been in close contact with somebody, I am permitted to take leave from my workplace until that close contact receives a negative test. Or, of course, if I'm symptomatic or have a confirmed diagnosis, I'm permitted to take leave under Executive Order 36 as well. But as we look at the interplay with emergency paid sick leave, unless, if we're not talking about the employee's own medical condition, unless that person has been placed under a quarantine order by a federal or local official, which could be the case for a close contact situation, right? So, for example, if through contact tracing, the public health department learns that, I'm a primary contact of somebody, during the contagious period, all of those things, and they order me to quarantine, then yes, right? So that's an example of a close contact that's covered under EO 36, but also qualifies for emergency paid sick leave. But unless I'm under a quarantine order, or I'm experiencing symptoms in attempting to seek a diagnosis, or my own healthcare provider is ordering me to quarantine, or I need to care for somebody in either of those categories, no, the pieces under Executive Order 36 would not qualify under emergency paid sick leave. And so 36, the way to think about that is really kind of unpaid protected leave, kind of like FMLA, if you want to think about it a little bit like that. So an employee is eligible to take protected leave from their job for the conditions in Executive Order 36, but it doesn't mean that those reasons necessarily are covered under the mandates under the paid leave provisions of the Emergency Paid Sick Leave Act. Okay, so next question, under Executive Order 36, a person had contact with a positive case and requests leave, but they work remotely and can continue to work. Are they eligible for leave? So it's close contacts. Let's talk about, again, this is a good example of the intersection between EPSLA, right, and 36. So under EPSLA, an individual is only eligible for paid leave benefits if they are unable to work. Under Executive Order 36, it talks about not coming to the workplace. So I would argue that Executive Order 36 allows you to take leave from the workplace, but doesn't necessarily trigger if you have work that can be done remotely and you are not symptomatic and you can perform that work. I think the employer has a pretty good argument to say you're absolutely fine to not come to the workplace, but we have remote work available for you to the extent that you're well enough to do it. Let's talk through that process. Obviously, that's very circumstance specific, but generally that would be a good approach to start to have. A few more questions. An employee has been granted leave to care for a relative, but now wants more leave until it is safe to return to work. Should the leave be extended? Does the state of emergency order have a role? So if the reason that I'm now requesting leave is just generally because I feel unsafe, if it's for no other reason, that is not leave that is required, whether it be through any of the state or federal mandates we've talked about right now in this presentation, or even through an association claim, right? So if you're saying no to this person just because they have a general fear to return to the workplace, you're certainly able to do that. In terms of where the state of emergency role may have in that decision, certainly it's guiding us to let us know, right, that the pandemic is still here and impacting the economy and public health in Michigan. And it opens up various resources of the state and federal government by that declaration. But the declaration doesn't necessarily trigger, except for, you know, it triggers a number of the executive orders remaining in effect. But it certainly doesn't require an employer to grant remote work or a leave of absence just because an employee has a general fear to return to work. So you would want to evaluate that request in the same way that you would evaluate a request from any other employee who's requesting an accommodation for a reason that is not covered or required of you as the employer by state or federal law. Okay, let's go ahead and move into a couple of scenarios, and I know some additional questions will come in, and that's okay, but we'll turn back to those towards the end of the presentation. Okay, first scenario. Scenario number one. So company is located in northern Michigan, so we're talking about Region 6 or Region 8 here, and was able to adjust to remote work for all employees during the first stages of the COVID-19 pandemic. But now that the company has moved into stage 5 of the My Safe Start plan, the company is bringing certain positions and employees back for on-site work. So we know that Region 6 and 8 are moving from a must for remote work to a should. Still certainly the preference, but now are permitted to bring folks who, even though those positions can be performed remotely, organizations are permitted to require folks to come back on site. So Edna employee lives with her elderly parents and is frightened that if she comes back to work, she could expose herself and her parents to COVID-19. Next slide, please. Edna employee requests to continue her remote work assignment because of her close contact or association with her elderly parents. Okay, so is the company required to grant Edna's request? So if we remember, let's kind of go through our mental checklist here. It doesn't say here that she is caring for either of these individuals, so we know, and it doesn't say that either of these individuals have a health condition, right? So we know that it's not eligible for FMLA. It doesn't say in the scenario that either of these individuals are subject to a quarantine order, either through the federal, state, or local officials, or their healthcare provider has recommended a quarantine and that Edna is caring for them. So that takes care of emergency paid sick leave. Now we turn right back to our Michigan requirements, Michigan paid medical leave. Again, that's related to medical conditions and care that Edna would be giving or support that Edna would be giving to her parents related to those conditions, and that is not at play here. Executive Order 36 talks about close contact with people who are symptomatic or have been diagnosed with COVID-19. That's not on the table here. and it doesn't seem like we have a fair a family care responsibility that even Edna, if she left, would be eligible for unemployment. So this goes back to elderly individuals are kind of just generally in that vulnerable population. So we've kind of gone through our checklist, right? So, and now we get to the ADA, and we know that this is not for Edna's own medical condition, so we know it's not an accommodation we have to grant. So is the company required to grant Edna's request? No. Okay, so being in close contact with elderly parents is not something that triggers the company's obligation to engage in either an accommodation request, doesn't trigger any protected leave or benefit obligations. So if not, and we know that's the answer, right? What should the company consider when evaluating Edna's request? So it's important here that this piece does not even necessarily trigger the ADA association analysis, right? Because elderly does not mean disabled, right? So we know that there are a number of types of conditions or types of demographics that could fall into this vulnerable population for COVID-19, but we remember under the ADA that threshold is disability, and elderly is not disabled. So again, when we talk about what should the company consider when evaluating Edna's request, remember that under our normal ADA association analysis, we would want to make sure that we're not making those decisions on discriminatory reasons based on legitimate business reasons, and certainly we would do so in this case as well. Even though that ADA association analysis isn't particularly triggered, that just makes good business sense, right? So we want to think about the reasons that we would grant or not grant, make sure that those are not based on any protected characteristic, and make our decision and document doing so appropriately, okay? Scenario number 2. So again, we have company. Company is located, again, in northern Michigan and was able to adjust to remote work for all of its employees during the first stages of COVID. Now the company is in stage 5 and is bringing folks back for on-site work. Edna employee again. However, Edna employee's spouse has a chronic breathing condition and is frightened that if she comes back to work, she could expose herself and her spouse to COVID-19. So next slide, please. Edna employee requests to continue her remote work assignment because of her close contact or association with her spouse. Is the company required to grant Edna's request? So again, we want to go through our mental checklist. So it doesn't say she's caring for this person, so we know FMLA is out. It doesn't say this person is subject to a quarantine order or even has been recommended for self-quarantine or isolation by their healthcare provider. So we know emergency paid sick leave is out. We turn to those state benefits. Michigan paid medical leave. Although this person, it doesn't say she's needed to care for this person at this point related to their medical care. So we know that is not triggered. As we look at Executive Order 36, it does not say that her spouse has been diagnosed or has symptoms of COVID-19. So we know that's not on the table. And in terms of even Executive Order 76, unemployment eligibility, we don't have any indication here that Edna is caring for this individual. So we know that we are not required to grant Edna's request, to grant her accommodation request, okay? But what's different about this scenario, of course, is that the ADA's association provision probably does come into play. And so remember, because we can probably assume, right, and this is a big assumption, we would want to go through the proper analysis on this, but we can just assume for scenario's sake that the chronic medical condition does hit the threshold for a disability, right? And so she's asking, I am around this person that has a disability, can I receive this accommodation request? So of course you're not required to grant it, but because the ADA's association provision comes into play, we are going to want to make sure that whether we grant, we're not doing so simply because of the reason Edna has requested the leave, right? She's requesting because she's around an individual, she's associated with a person with a disability, and that's the reason she's requesting leave. And so we don't want to draw our employment decision simply based on that reason. And so, of course, we want to consider the request based on those non-discriminatory basis. And as we talked about, the company can absolutely take the position that they cannot accommodate a request for remote work or leave of absence outside of those that they are legally required to grant. That's an absolutely fine position to take, and you absolutely may do so, okay? Scenario number 3, a little bit different. So Edgar, employee, has an approved 1-week paid vacation coming up at the end of July. His mother is coming into town for a visit, and his mother has a chronic breathing condition. So maybe way back when he knew that his mom was coming to town and took the last week of July off so that he could show her the sights and hang out with her, okay? But now, right, she's coming to town, she has a chronic breathing condition, he's been back on on-site work, the pandemic is still going in the community, so now he requests a 2-week remote work assignment and or an unpaid leave because he wants to self-quarantine before her visit so that he can limit any potential COVID-19 exposure. Next slide, please. So the company recently granted a coworker's request for an unpaid leave. So the coworker could attend a parent-child camp with their child, and they did that in June. But that would allow the coworker to save his paid time off bank for a planned vacation the coworker was taking in December. So just a quick recap, right? So we've got a coworker who has a vacation planned in December they want to save their PTO for. The company just allowed them to take an unpaid leave off work for a period of time at their request, despite having the time in their paid time off bank to do this camp. So now Edgar has requested either 2 weeks prior to his vacation to have the ability to work from home so that he can make sure he's out of the incubation period in case he has been exposed while at work, or even just a leave of absence for that time. So is the company required to grant Edgar's request? So again, if we go through our mental checklist, we know that this is not related to Edgar's own medical condition, and it doesn't seem to be related to his ability to care for his mother, who her health condition, just for sake of argument, we can say that it hits the serious health condition threshold, and let's just say it hits the disability threshold. But there's nothing in our scenario here that indicates that care, Edgar's need to care for his mother, so we know FMLA is not implicated here. Mom is nothing in our scenario indicates that mom is subjected to a federal, state, or local quarantine order or has been advised by her healthcare provider to quarantine, and Edgar's not required to care for her. So we know emergency paid sick leave is not in play as we turn to Michigan law. Michigan paid medical leave. Again, it doesn't seem that that Edgar is needed to care or support mom for a healthcare related reason. So we know that's not into play. And when we talk about Executive Order 36, nothing in our scenario indicates that mom is symptomatic for COVID-19 or has been diagnosed and Edgar's been in close contact. Okay, so we know that there's nothing in Edgar's request that requires us to grant his request or engage even in the conversation. But if not, right, so we know we're not required to do so, but what should the company consider when evaluating the request? So remember, we want to base it on those non-discriminatory reasons. And what's a little bit different about this scenario is we have coworker in play here, right? So if the company grants a request for unpaid leave for certain personal or family reasons, it would be a violation of the ADA's association provision to deny Edgar's request because he wishes to use the time to assist a disabled family member, right? So So we considered the request for Colin, and we said yes, and that's fine. And we're going to consider the request for Edgar, and we can make the decisions we're going to make, as long as we're not saying Colin's reason is fine, but Edgar's reason is not fine, because we're not going to grant requests related to vulnerable individuals. Now, certainly, if Edgar's role, you know, the company remains free to deny his request based on those legitimate business reasons, right? So again, generally those requests, you know, if they're based on seniority or first come, first serve, or the company cannot accommodate Edgar being out. He's a very critical employee and he needs to be on site, and certainly can't be on a leave of absence outside of anything we're legally required to provide. That's fine. Just because we granted Colin's request doesn't necessarily mean we must grant Edgar's request, but the reason that we deny Edgar's request can't be because of the reason, right? The personal or family reason that he's requested the leave for, when we have granted Colin coworkers personal or family leave request, even though we weren't required to do so. So again, it's just getting into those details and making sure that if we do not feel we can accommodate such a request, we're considering those things based on those legitimate business reasons and nothing that's protected under the law. So in summary, before we get back to some additional questions, next slide, please. This is the analysis that I want you to start to think about. And again, we'll have this webinar and the slides up, you know, later this afternoon. And so you can print this or screenshot it or save it, all of those pieces. But it's important for us to think about it like this. So when you receive a request for an accommodation, such as remote work or a leave of absence, think to yourself, must I consider the request? But then what should I do to even evaluate that request properly, right? So back on June 17th, my colleagues, Sarah Willey and Mary Tabin, did a webinar specifically talking about EEOC updates and spent a good amount of time talking about the reasonable accommodation process under the ADA. And so talking a little bit about medical verification, talking a little bit about making sure that you understand the healthcare provider's analysis of what a reasonable accommodation could be. So if you need help on that piece, I'll turn you back to that particular webinar. And also available on our resource center, we have a number of resources that help you kind of work through a request for a workplace accommodation. So we have forms for employees to make formal accommodation requests. We have copies of the medical certification that you want to have. Working with that individual's healthcare provider. We have a decision-making flowchart. We have some of those resources available right there in the Resource Center. So again, as we look back at our analysis steps, make sure we have a good understanding of what requests we are required to consider and the things that we should do during that consideration to make sure that we have the information we need to properly consider those requests. But even for those that fall out, think about, may I consider the request and how should I evaluate the request, right? So this is an accommodation I'm required to grant by law, but should I consider it? And that'll be very specific, obviously, to your business, but also making sure that you have a good understanding of what requests you have granted thus far and the reasons you have granted them to make sure that we're not drawing lines based on discriminatory reasons, even though that certainly was not the intent. Okay, next slide. And there I am in my contact phone number, but more importantly, I'll have you go to the next slide and provide a little bit more information about our Back to Work Resource Center. And while that information is up and viewable, I will go back and we'll address some of the existing questions. Let's see. Are employers who have had employees working remote since March able to recall non-essential workers who can perform work remotely? Are they able to call those employees back to in-person work at this time at their discretion? So let's talk through this a little bit. So a couple of weeks ago, and I certainly understand how difficult it is to keep this straight, our updated, what I'll kind of just colloquially call our stay safe or stay at home orders, we transitioned away from, right, this essential worker classification, right? So our old orders said only persons in the, performing these types of work are permitted for on-site work. And if you don't fit within those categories, it is not permissible for you to be back at work. So instead, depending on what region you're in, you are now subject to Executive Order 110 or 115, and those orders are a little bit different, right? Instead of saying unless these are the only things that you are permitted to do, those executive orders are saying unless we specifically say you must remain closed, these are the things you're allowed to do. And so certainly there's a number of social implications there, right? So, right, we can go to restaurants and we can travel and those types of pieces. But under Executive Order 110, the rule is still remote work where possible, right? So if you've been allowing remote work and it still remains possible, and things can change, just because remote work was possible 3 months ago doesn't mean it's possible today, and there can be a number of reasons, right? Perhaps your business has picked up and the things that you need somebody on site to do have changed because of the change in your business. So for those regions who are under Executive Order 110, remote work is still the rule where possible. For those in regions 6 and 8, and you are under Executive Order 115, remote work is still the preference. So all of that background to say, you are able to call back employees even though they have been working remotely, but the difference on whether you can is dependent upon what executive order you're under, because if remote work can be performed remotely, what you're asking them to do today, what their job is today, if it can be performed remotely and you're in Executive Order 110 region, remote work is still the rule, okay? But if you're in 115, you can call them back. Making those decisions, again, based on the type of work is the important distinction there. Okay, let's see, next question. We have an employee that is currently furloughed due to COVID-19 and their child and family members are suggested to stay home per physician's orders based on the child being high risk. What are our obligations if we've called this employee to come back to work at this time and the doctor provides confirmation that she needs to stay home? So so let's talk about this a little bit. So we've got the child who is high risk, and so the physician has said that the child needs to stay home, and potentially family members to limit exposure. If the doctor is saying employee needs to self-quarantine, that is a reason, right, that's covered under the Emergency Paid Sick Leave Act. So I have been advised to self-quarantine by my healthcare provider. It doesn't mean that my healthcare provider has said I'm doing so for my own medical condition. It can be for someone else's medical condition. So that can be a trigger, right? So if we've got that doctor's piece, we know that the Emergency Paid Sick Leave piece is triggered. But remember, Emergency Paid Sick Leave is only a maximum of 80 hours. So let's pretend that we've exhausted Emergency Paid Sick Leave, and what do we need to do at this point? Well, the analysis goes from what must I do to what may I do to what should I do, okay? So we certainly, this person, let's presume that the child has, has a condition that meets the disability threshold. And so as long as we are making a distinction for allowing the accommodation to work remotely or staying home, not based on that association, we are free to make the business decisions that we need to make because this person is no longer covered by any federal or state mandate for us to provide the leave or an accommodation, right? Again, we want to run through that analysis. Make sure it doesn't hit any of the FMLA categories. Make sure it doesn't hit any of the emergency paid sick leave categories, right? If they've exhausted time, make sure it doesn't hit Michigan paid medical leave, make sure it doesn't hit Executive Order 36. So once we've been through that analysis, we know that we're not in a must provide the accommodation, it's just the may. And if we're saying no to this person, that's permissible as long as we haven't granted an accommodation for other reasons that wouldn't that not granting it here would be seen as discriminatory based on this employee's association with a disabled individual. Okay, so that's the analysis that we want to run through. None of these things are easy. And of course, as we look at, again, what must I do, what may I do, what should I do in the event that, because of kind of the times that we're in right now, you don't necessarily have to jump to termination if that's not something that you're prepared to do. You know, long-term, you know, unprotected, you know, type of a leave of absence, if that's something that you want to consider. Again, as long as we're doing those things on a non-discriminatory basis, those are certainly in the purview of the employer. Okay, last question. 2 high-level administrators are working with accommodations related to working remote because of a high-risk individual, have told me to follow my usual process, but without any review of requests. They have also stated the person won't qualify. Suggestions on addressing this specific to COVID. I think what this is saying is you have an employee because of their own health condition has requested an accommodation. And depending on the health condition, that could qualify as a disability. And so from the disability analysis, right, we know, let's just for argument's sake, say it does hit that threshold, we know we have to, we have an obligation to engage in that interactive process and think about accommodations. Remote work certainly may be a reasonable accommodation. Leave of absence could be reasonable. It all depends on the circumstances. So what I would recommend, right, we would want to just go through our regular ADA or, you know, FMLA if this person has a serious health condition and needs to care for themselves, whatever that situation may be. But you do want to follow your usual ADA process, right? And so we want to get the medical verification. We want to make sure that we're engaging with the employee and the healthcare provider to verify that the condition meets the threshold of disability, and we have a good understanding of what those accommodations may be. Certainly, we have a general idea maybe right now that when we talk about high-risk individuals that we assume that means remote work or leave of absence, but there are other accommodations that could be appropriate, right? Depending on the person's job, perhaps they just need to not interface with the public right now for a period of time, but they can still work on site. And so you do still want to go through, you know, your normal ADA type of analysis with that individual. Okay, so it has been a great morning with you, and certainly we have, again, our Back to Work Resource Center. If you have needs in terms of letters, forms, decision-making documents, all of those are located there. And we'd love to have you as a subscriber. If you have specific questions and you need specific advice, I would encourage you to reach out to your favorite Miller Johnson attorney and seek guidance on those pieces. Other than that, it has been a good morning, and I wish you all a safe holiday weekend. Thank you.